Joining me right now is Joseph Newberger. He is a criminal defense lawyer in the city of Toronto. Mr. Newberger, thanks for your time, sir. And let me start with this.
Pleasure.
You've got two complainants, both with very similar stories. Hoggard said that both sex acts were in fact consensual. The jury believed one of the complainants and not the other. What do you make of that?
Well, when you were dealing with the lady from Ottawa, there was that recording which was put into evidence and she was cross-examined on. And in the deliberations, the jury clearly focused on that recording and asked for both a playback from Mr. Hoggard's evidence, but also from that actual recording. And that recording, and I think I've said this a few times in my commentary, it's sort of real-time insight into their dialogue, the feelings, and what their state of mind was at the time. And in that recording, there's an interesting exchange where he asks, why she felt the way she did, because this recording happened after she had sent the text about feeling sexually assaulted. And she said, "I don't know, just about every time I was trying to say no to you." And so there's a lot of content in that recording, which was partially beneficial to the defense, but also partially beneficial to the Crown, because it can be relied upon as to some extent as a prior consistent statement where you really get some fairly good insight into her state of mind. And the issue was consent. And although there may have been prior consent through messaging and arrangements, that consent can be withdrawn at any time. So I think the recording was a factor. I think some witness evidence with respect to her disclosures afterward, they were factors. But you raise a good point, Steve, that we have two very similar allegations, and the jury could have applied evidence of one to the other. But this is how they wound up with the verdict, and certainly they worked very hard on this.
So could they have, and that's a good segue into my follow-up, could they have, if they accepted the evidence of the one, could they automatically have accepted the evidence of the other, given the fact that the acts were so similar in nature? Or are they suggesting that the one woman did not agree to the similar act and the other woman did agree to the similar act? Does that make sense to you? How do you figure that out?
Yeah, so in a case where you have a multi-count indictment between two complainants, there are rules that the judge will explain to the jury as to how they can apply the evidence on one to support the other. But you also have to take a very careful look at the evidence of the younger complainant and assess it on its own as well, in conjunction with Mr. Hoggard's evidence. So in totality, they may have felt that the Ottawa woman's evidence was not sufficient to lend support to the evidence of the young complainant, and they felt in that case that the Crown has not achieved the burden of proof beyond a reasonable doubt. So there is the ability to apply some evidence to the other count because of similarities. There are a lot of similarities, but there are careful evidentiary rules about how to do that. And it just seems that the jury focused in on this recording and other sort of objective evidence that they didn't have on the other count.
Very complicated situation, and thanks for breaking it down for us. Thanks for your expertise.
My pleasure. Take care.